All right. Well, thank you, Christy, and thanks everybody for joining us today. I echo those sentiments about working with the folks in Colorado. Matt and Christy and their team have been great to work with, and we've known each other for a long time and worked together on all sorts of issues. So obviously, folks on the call, feel free to reach out to us if you have issues. My contact information is going to be at the end. So yes, I'm CEO and Chief Legal Officer at Compliado. Compliado is a company. Oh, well, let me start. I am a lawyer, but I'm not your lawyer, so I always have to give the not legal advice warning at the start, just because we don't have a attorney-client relationship. But obviously, we'll be talking about a lot of legal and compliance issues today. So Compliado, if those of you who don't know, we're actually only about a 5-year-old company, but we've grown super fast, gone from sort of 0 to 10,000 dealers all across the United States. We work with, that number actually is going up soon. I think 44 of the 50 states we work with, including Colorado. Most of our folks worked in dealerships. I worked at NADA for a long, long time. We have another ex-NADA lawyer works with us. We are dealers, built by dealers for dealers, and that really is true. We only work with auto dealers and dealerships, and again, it's there's a reason we've sort of grown so fast. I mean, I've been here about a year and a half myself from NADA, and frankly, on a personal note, I'm here because I knew the folks that were here. I knew the software was just head and shoulders above everything else out there. So it's been nice to be here and be able to really help dealers with these issues as a practical matter. So we're going to talk about an issue today it's a little bit of a strange issue. It's a sleeper issue. It's becoming a little bit more understood, or at least, people are more aware of it than they were 3 or 4 years ago. It's the kind of thing where when you first come across it, you're like, really, is this an issue? But it really is an issue. And I will tell you that I have been shocked in my time here at how prevalent litigation is in this area. We've seen a number of enforcement activity as well. We'll go through all that. But there's a lot of concern amongst both regulators and now it's concern among regulators, and I think opportunity for the plaintiffs' lawyers who see an opportunity to bring litigation against businesses of all types in relation to these issues. And we'll talk about sort of what the issues are. And it's the kind of thing that dealers do every day, and you can really get tripped up if you don't realize what the risks are to you as you go forward. So we're going to talk about the background, sort of give you an overview of what's going on. I'll mention the legal theories. It's actually kind of complicated because for a whole variety of reasons. One is it's sort of a complex area of the law. Second, the plaintiffs' lawyers are always sort of looking and probing for the next area where they can have some success in litigation. And so the theories tend to change, and the stakes are increasing, because ultimately where they always want to get is to a class action. That's where they get the most, the extract the highest settlements and bring the highest damages against people. And we're seeing where that's sort of becoming more and more prevalent today. So importantly, we'll talk about what you need to do to avoid becoming a target. And we'll talk a little bit at the end about some tools that we provide that are, frankly, there's nothing else like them, not just in our industry, but any industry I'm aware of, to help companies to stay on top of this. So, okay. So what are we talking about? We're talking about website cookies, but really, look, it almost seems too simple to start here, but let's just start here. Websites, this is where business goes on. It's your electronic storefront. There's probably more activity online for most dealers. I would say the overwhelming majority of dealers than there are. People used to walk in the store. Now they come in first on your website and come across you electronically. And because of that, and because of the fact that dealers are frankly fairly advanced among even retail entities in the United States in terms of the types of tools that you employ, right? There's lead capture, there's chat bots, there's online credit applications, there's sub windows and subdomains and things that can open up, and all sorts of functionality that you're doing, scheduling appointments, following up with people on your website. It's not just here's our inventory. There's a lot of functionality going on there. As a result, think about the information you're getting on your website, right? I mean, if you're taking online credit applications, you are getting very, very sensitive, very valuable consumer data that is very highly risky. It's also very highly sensitive, and it's the kind of data that's very much protected under state and federal law. Not only that, but the tools that are employed on these websites, cookies, scripts, pixels, whatever you want, whatever names you give to them, those all sort of mean slightly different things. what they're doing is their technology that's trying to build a picture of the person that's shopping on your website, right? So Brad Miller comes to Miller Motors website, right? And I just want to look around, right? There are things called cookies that they're called cookies for a reason, because they leave a little trail of crumbs across the internet that you can follow. So you know that you may not know that my name is Brad Miller, but you may know that I've been to these previous other 4 different websites, and I'm looking at a Silverado on your website. But then when I go to Facebook, I'm going to be served up F-150 ads, right? That's ultimately the goal here, is you want to track to know what's going on your website. That's sort of called analytics data. That tells you who visited, how long they stayed, what they look at, those kinds of things. And then targeting or retargeting data means you can then take an ad and target it to me based on what I've done on your site and other sites across the internet. Okay. That's very powerful from a marketing perspective. Most all dealers are doing this actively, and frankly, it's not, there's nothing wrong with doing it per se. The problem is, if you're now doing this without consent from the consumer, you've got a potential compliance risk and a litigation risk and a privacy risk. Okay. So that's essentially what we're talking about. You're deploying these tools on your website to know more about who's visiting your website and who and where they're going to serve. Ultimately, you want to improve your marketing visibility, right? We all want to do that. And in fact, most consumers want to do that. But the problem is there's a risk. You got to get consent. So I'm sort of bearing the lead. We'll talk about how you get there and what that means. But that's essentially what we're talking about. So again, it's sensitive. It's personally identifiable. And the issue here is, as I said, Brad Miller comes to Miller Motors website. I know as a consumer that I'm interacting with Miller Motors, and I anticipate, if I give you my name, or even if I say, I understand that you're going to know a little bit about me because I went to your website, right? Maybe. But what creates the issue is when this information is shared with third-party advertisers or OEMs or marketing companies or Meta or whoever it is, Google, then you have just taken information that Brad Miller didn't know. I didn't know, and I didn't say it was okay for you to share that with somebody else. That's essentially the issue, right? And regulators and increasingly, as I said, plaintiffs' lawyers are really holding dealers to task to make sure that that consumer right in terms of knowing what's going on with my information is protected. So that's what we're talking about. I will also note that last bullet point is very near and dear to my heart. I spent 16 years at NADA, partly dealing with OEM data sharing agreements, with DMS integration issues and sharing issues. Dealership, the data that you have on these websites is incredibly valuable, and it's valuable to you. It tells you who's coming to your website. These are your leads, right? These are your customers, potential customers. And that is something you spend a lot of time, energy, and effort garnering and protecting. And frankly, you should know if there are third parties in there loading these tools onto your site, they could be extracting this information from you without you even knowing it, right? So as a practical business matter, let's put aside the lawyer stuff. You ought to know what the heck's going on your website, because these, it's sort of akin to what was happening in the DMS world 15 years ago, when you had all sorts of third parties sucking data out of your DMS and dealers didn't know. And they're like, what the heck? This is my information. Why are you taking this? It's almost on that scale electronically, and it's hard because it's very difficult for dealers to get a sense of that. So we'll talk about that as well. Okay, so I alluded to this, but what are cookies? What are we talking about? Look, like I said, they can be called scripts, they can be called pixels, they can be replay tools. There are all sorts of ways that it happens, but it's a bunch of technology. Like I said, it's actually code that gets loaded onto I'm Brad Miller on Miller Motors website. It's code that gets downloaded from the site onto my machine so that you get information about who I am and tracks me across the internet, right? That's essentially what it is. And of course, to me, as the user, as Brad Miller going to your website, it's invisible, right? So that's the problem. They operate silently in the background without my knowledge or potentially my consent. And that's essentially what the problem is. So again, here's a little more detail. You'll get these slides at the end, obviously, but a little more detail on what I'm talking about. Pixels, scripts, chat modules, session replay are particularly interesting. That literally just records everything that happens while the person was on the website. So think about a dealer website in particular. I mean, some of these tools are used in all sorts of businesses, but those businesses don't get people that do online credit applications. I mean, think of a chat bot. There are things that people tell you or a chat bot or whoever it is, an AI, lots about them. So I had a bankruptcy. Do I qualify for this special, right? That's not only non-public personal information, that's credit related information you're going to be protecting, right? So think about that as it's being shared. So again, they're embedded deep in your website. They're often bundled with advertising or analytics services. So again, this is what we're talking about. There's a couple concepts here you have to get, which are these technologies. You have to get broadly the concept of analytics versus targeting. So it's a little bit hard to always understand what that is. Analytics, like I said, that's generally ways to track what's happening on your website. So you don't know Brad Miller was on for 20 minutes, but you know I was on for 20 minutes. You know someone was on for 20 minutes looking at the following pages, right? And then you can see what the most popular ones are, where people hovered over, where they stopped. That's classic analytics. Then if you take that information and then you serve me an ad somewhere else on the internet based on that, that's retargeting or targeting. And that's specifically dealt with under state law differently, and I think a higher level of risk. And we'll talk about that as we go through it. So again, here's a little bit more. This is just, you don't have to look at this now. This is something for you to look at later. We've got more resources on our website, by the way. We have a whole 35-page guide with all the great details. But you do have to understand there are hundreds and hundreds and hundreds of cookies that probably load on your website. Now, many of them are what they either call essential or functional. So they're either, if you didn't load these cookies, the website would break, like it wouldn't work right? Like it may be to display your inventory or to make an appointment in service or something like that. It actually functionally, it's a cookie that that needs to be on there to make sure the information displays properly. Those generally don't need consent. Below the line, the analytics and the targeting generally need consent. That's sort of the bar. Now they're both called marketing because they're both gathered for marketing purposes, right? So we've talked about it enough, but that's essentially what the difference of those things are. There's first party, there's third party, there's a lot more to this that I'm going over, but at a high level, you just have to understand there's sort of essential and then there's marketing cookies. And the marketing ones, you really need consent before they're loaded on the website. Okay. So I'm going to play video in a second. And I just want to set this up a little bit because we took this off a real website. It's I think it's been a few weeks or months now, but we've sort of blacked out who it is. It's not ours, obviously, but I wanted to show this to you just as a way to understand what a little bit of a taste of what's happening on your website, whether you realize it or not, and B, how easy it is for third parties like plaintiffs' lawyers to go find out what's going on your website. Literally, you just right click on the website, you inspect, you can see, and frankly, we see this all the time. They'll just cut and paste it and put it in a complaint or a demand letter and say you violated this statute that we'll talk about. So again, here's a sample of a video that I will play in a second here. Hopefully you'll be able to hear it. It's a couple minutes long. Again, there's going to be a lot of jargon thrown at you here. I want you to just sort of note a few things, which is, I mean, this is all happening before any cookie banner has been no selection's been made. And again, how easy it is for anything. And this is no special tools that we have. This is just what's available on a regular person's website. So let me try to play this. And I will.
On your page. First thing you're going to want to do is right click anywhere on the website to show, take a look at a random. Today we're going to take a look at a random website to show you how you might be able to look at your website to see the types of third-party data that might be being sent and third-party cookies that might be being set on your page. First thing you're going to want to do is right-click anywhere on the page, scroll down to the bottom of the menu that pops up and click Inspect. Then we'll want to jump over here at the top here. You'll see we have these different tabs. We're going to jump to the Network tab. Now, this isn't really a good representation of everything that's being sent and received on this website. So to see all that, what we want to do is kind of reload the website. So we can click anywhere in the URL, click Enter, and that will effectively reload the website. We'll see there's a ton of traffic coming in and going out when we reload. Now, not all of this traffic is going to be related to some sort of third-party collecting information about user actions. If we organize by method and go down to post, which is the sending of data, we will notice that it does appear like there might be some sort of collection of user actions by third parties happening here. Now, if we jump over to the application tab and we click on the first item here, which will tell us the cookies being set directly on the page that we happen to be looking at, we'll notice that there's an awful lot of cookies being set. It can be hard to discern in situations like this, first-party versus third-party cookies. This is directly on the domain, and we would assume as such that technically these are all first-party cookies, and a lot of them may be. However, when we look at these, it does appear that we have some interesting setting of cookies by third parties. We also notice if we look below the domain of the website we're looking at, we see a lot of third-party domains listed. This is indicative of cookies being set by third parties happening on the page that you're looking at.
So yeah, it's this. I know that was a lot, and again, you don't need to know necessarily all the terminology she was noting. But I don't know if you saw, there were probably 550 plus cookies being set on that site right now. A lot of those were essential and functional, but a lot of them were third party, and it was gibberish, right? It doesn't say this is what this cookie is and this is what it does. It's going to be difficult to tell what it is. So it's very hard sometimes to even know what's happening on your site. So I will note there was a cookie banner on that site, but all that happened before any consent was given by the person, right? So I'm a visitor to that website or a website like it. All that stuff is loading before I've said yes or no. So again, I won't belabor it other than to say my takeaway is not, Brad, I need to figure out what she means first party, third party. How did she do that again? What button did she click? I want you to visually kind of see what you're dealing with in the scope of it, because it can be quite daunting and there's a lot of it going on. And there are OEM cookies that are being put on there. There are third-party cookies being put on there. And do you know what the heck is happening, right? That's really the question. You also need to know a little bit about the structure of your website. You could have iframes. You could have things that pop up and it looks like your website, but it's actually a third party that you've engaged with, right? And are those loading separately? Is that a separate URL that has its own cookies that you have to control? Subdomains, right? It gets complicated pretty quickly is kind of my takeaway. And there's a lot of ways that you can kind of go wrong. Okay, so now I've sort of, confused you with all the terminology and scared you with, I mean, it's not scary. We literally just picked that at random, and that's pretty representative of what's happens on dealer websites. It's a lot. There are a lot of cookies that are going on. So what's happening? These things are loading and I didn't consent to them. Why is this creating a risk for you as a dealer? First of all, there are lawsuits being filed, generally under both under state and federal law. But oddly enough, the basic theory under most of these lawsuits is that they violate state wiretapping statutes, believe it or not. So wiretapping, for those of you who remember, literally there are most states in the union have laws on the books that say it's illegal to tap into the phone line that connects one person on the phone with another person on the phone. Back in the day when phones actually were connected with copper wires, you could stick a device called a pen register or another kind of device into the wire and you could listen into the conversation that was going on. And that was obviously a problem from a privacy perspective. And a lot of states stepped in and said, there's a law. You cannot intercept a communication between two people using a tool that does it without the consent of both parties on both ends, right? So the way I phrase that is important, because think about what's happening here. The theory is by using these cookies and loading these cookies on the site without me as Brad Miller, the visitor, knowing, you violated the state wiretapping statute because you've intercepted a communication between me and the website and shared it with a third party, that is Google or Meta or whoever it is, or Adobe or whoever's loading these cookies on there, right? And it sounds kind of silly, but the reality is this has worked. This theory has made it past the pleading stage in a number of state and federal courts. So there are state wiretapping statutes. There's actually a federal wiretapping statute as well. And so the gravamen of most of these complaints, the underlying fundamental claim is that you're violating the state wiretapping statutes, right? The California version, which has gotten the most action, is called SIPA, and it allows for statutory damages, right? And that's kind of the deal. So statutory damages means you don't have to prove harm. You just have to show they violated the statute, and you get damages based on the number of times. So you'll get a letter saying, hey, you loaded these cookies without my consent. That violated SIPA 5 times at $5,000 a pop. That's $25,000. Pay me or I'm going to sue you, right? That's essentially the flavor of what, and there's thousands and thousands of these demand letters going out all the time. So that's state and federal private lawsuits. And those are, as I said, under state law, becoming increasingly class action. We'll talk about that in a second. And there are also lawsuits under state privacy laws. So Colorado has the Colorado Privacy Act, CPA, the Colorado Privacy Act. You're one of now 19 states in the country that has a privacy law. There are provisions in the state privacy law that talk about retargeting cookies and having to get consent or having to allow people to opt out before using targeting technologies. And if you're not complying with that, that can lead also to claims under the state privacy laws. We'll talk about that a little bit more in a minute. There are also, under both federal and state law, claims that this is just violates the federal or state unfair deceptive acts or practices statute. So they're just saying it violates our consumer protection statutes by not giving me the choice as to whether you're doing this or not. So a lot of plaintiffs will throw in the kitchen sink of claims, but some of these claims will be under state law, federal law. Sometimes they even bring state common law claims like trespass or trespass to chattel or things like that, invasion of privacy, right? So there's lots of different theories. It's not just state privacy law. That's the thing I want to take away. There are a lot of people confused. They're like, I don't get any personal information when I load these cookies, so I'm okay. That's not the case. It's the act of using the cookies itself that leads to the potential lawsuits and that leads to the claims under state and federal law. Okay. So, and I see some questions. I'll try to get to the questions at the end. Good questions. I'm not ignoring them. So again, I talked about this a little bit more, but again, look at this when you can. Federal wiretapping claims are pretty common. As I said, FTC, by the way, the FTC has brought enforcement actions in this area as well against companies for this very thing, loading these cookies without consent. If you hear me say that 20 times, the key is get consent for this, and then these issues generally go away. If you don't get consent, that's when you get the wiretapping violation, the FTC Act violation, the state wiretapping. Pen register is sort of, sometimes they use the pen register claim. There's a whole bunch of technical legal reasons why they do that. That's what they called the thing that actually tapped into the wire. There was like a device called the pen register. If you ever hear that term, lots of those were filed for a variety of legal reasons. It could be just that you're recording, if you're in a dual consent state. So some of you may know that every state also has statutes about when you can record a conversation between two people. And if you're in a dual consent, meaning you have to get both parties' consent, and I didn't consent, and you're doing something that records what I'm doing, sometimes those claims will come in there as well. So I don't want to overdo it other than to tell you there's a lot here. It's not as simple or straightforward as you might think. And there are a lot of ways for the plaintiff's lawyers to get pretty creative in asserting allegations in this area. And of course, when there's statutory damages, that's like manna for plaintiff's lawyers because they don't have to prove damages. They just say, you did it. And because you did it, you got to pay me this money, right? So we're seeing this more and more. Okay, so one of the first questions I always get, isn't this just a California issue? You talked about this SIPA thing. I've heard that's going on in California, but I don't have to worry about that in Colorado. Unfortunately, no. SIPA is still probably the most common cause of action, but increasingly these plaintiffs' lawyers are suing people in every state in the union. And they're claiming that I'm in California and I visited your website in Colorado and you violated this reality. Even though you're not in California necessarily, I'm still suing you under the California state law and therefore pay me money on the statutory damages. I'll talk about the Briskin case in a minute, which is an interesting one, came out on the Ninth Circuit recently, where the Ninth Circuit, which is an appeals court, not a district court, it's a federal appeals court, actually bought the theory that an out-of-state defendant could be sued under state law in California based on the fact that the person was in California when the violation occurred. Again, there are higher risk and lower risk jurisdictions. California is the highest risk. I'd include Pennsylvania, Illinois, and Florida in the high risk as well, mainly because their state wiretapping statutes have been the most fruitful but a lot of this depends on the wording of these state statutes, right? And the wording of these states is just most susceptible to these kind of claims. So as you see the bullet there, it's one of the reasons we actually, in our tool, you can set up what's called geofencing. So you can actually have a banner that is set to a certain setting, but if somebody's coming from California or Florida or Illinois, we detect that for you and give you a different banner that's sort of a more protective banner. So that lessens the risks of some of these out-of-state plaintiffs. But this is happening all over the country. Is unfortunately what we're really seeing. And so, a lot of folks will treat use these geofencing tools to treat things differently. And we can talk about how you can set it. Look, at the end of the day, I can only speak for our tool. We set up a tool that you can set to what, it's sort of like 0 to 10, right? You can set it up as most restrictive or least restrictive. And there's a trade-off here we're going to talk about in a minute, but you got to kind of have to figure out as a policy matter where you want to set that, see what the impact is on your data that you're getting. And you can keep that as appropriate for your operations as you want it to be. So again, I'm not going to get into this. This is just an example of some of the other things we're seeing. They're getting creative in all sorts of ways. We've actually seen email wiretapping claims, the Video Privacy Protection Act. So I won't get into all this other than say plaintiffs' lawyers are very creative. And again, they get a little success, and all they need is success at a district court level or a state court level to get them past the motion to dismiss, and they start sending out demand letters hoping to extract settlements. So that's unfortunately where we are today. So again, I'm not going to spend time on this. So I talked about SIPA a few times. We've talked about this for the most part. But if you ever hear the term SIPA, it is California driven. But again, they're suing people all over the country under this California state statute. Again, and I touched on this. I'm going to touch on it more. It started with SIPA. It started with the wiretapping. Now they're getting more into the UDAP, state privacy law. The New York Attorney General actually came out with a guidance some months ago that New York doesn't have a privacy law. New York doesn't have a wiretapping law that applies. But the New York AG nevertheless put out a guide that said basically, hey, it violates our state consumer protection statutes if you don't have a cookie banner that works in a specific way, right? So there are lots of ways you can get into this. My message to you is, it doesn't matter if you're in Colorado, Alaska, Hawaii, or Arkansas, or California. You need a cookie banner. You need one that works well. So we'll talk about this, some of this more as we go along. The last piece, again, this is interesting. I will tell you this. What we're finding is happening is, so a couple of years ago, I think you look at websites and you've seen a lot of them didn't have any banner at all, right? That was a problem. Now, increasingly, folks are getting a banner. Now, obviously, use our banner. This isn't the case. But there are folks, not just dealers, but others that are using these banners that frankly just don't work. Like I don't want to pick on that video I showed, but that website had a banner on it, but it didn't do anything because all that stuff loaded before the consent was given. So the problem with that is when you do that, when you deploy a banner that doesn't work properly or doesn't work as it states, right? The banner is going to say something like, we block cookies. Do you want, or we load these cookies, but you can block it if you say no, thank you. You say no, thank you, and it doesn't block them. You've just opened yourself up to a deception claim under the state UDAP and on a class action basis. That's what we're seeing is now people are loading these banners that don't work or don't work as advertised. And all of a sudden it's easier for the plaintiff to show that you had, I don't know if I just had a technical issue. Sorry about the glitch if that sparked out there for a minute. But I don't have to show individual harm or individual violations. I'm just saying your banner is deceptive. Therefore, I'm bringing a class action on behalf of everybody who visited your website. So anyway, I think that just makes the risk calculus even a little bit different, right? It's one thing to be sued individually into these state statutes, but to have class actions brought based on the way your banner works is a whole different ballgame. So just something to be aware of that we're seeing. So again, not just dealers. We've seen website providers, we've seen OEMs, we've seen finance companies, inventory listing sites. They are focused a lot in the auto space. I mean, we get a lot of data, and a lot of personal data, a lot of consumer data, and so it's a relatively fertile place for these kind of lawsuits. Okay, so we talked about this. So that's sort of the background. Those are the legal theories. That's what we're seeing, and it really is not. It's been very aggressive and active lately, and it's not slowing down. What's the practical side of these things? So the practical side is, as I mentioned earlier, I'm just going to repeat this. This is valuable data, right? Hundreds of cookies being loaded on your site. I mean, I'll just tell you, frankly, when I was at NADA, I worked on, I think I mentioned this, worked on the agreements that you have with your OEM, that's your data sharing agreements. You have an agreement, whether you realize it or not, with all your OEMs, right? That governs how information goes back and forth between you and the OEM. And a lot of times these agreements would have provisions in there about the OEM or a third party being able to put cookies on your website and take that information and use it for heaven knows what, for marketing for the OEM, for you, it was unclear, right? So I'm not just picking on the OEMs, but there are a lot of folks that want to load cookies on your site because they want this data, right? So you have to know what's going on so you can protect it. So obviously it's not just you that wants it, the OEMs, your vendors, marketing companies, Google and Meta, this is their business. They're the biggest companies in the world. How are they so successful? Retargeting, right? They sell this information so that your ad is more powerful and they know what's been going on so that they can sell ads on Facebook or whatever it might be, right? That's essentially why they're the biggest company in the world. So they want this information. Obviously, it's very valuable. So what happens? So I've mentioned this a few times. You have to have a banner that gives the person the choice to say, no, thank you. You have to say, here's what we do. If you don't want us to do this, tell us. And you actually have to stop if they tell you to stop. Well, so what that means is if you have a banner that works and follows the law, it will have an impact on the analytics and the targeting data you're going to get from your website, right? So this is kind of what we've seen. Now, there's no magic to this. I can't stand behind it. This is anecdotal. We have 10,000 dealers, so we have a pretty decent data set. But we'll see about 30% of the people will, if you give them a choice, do you want to accept this stuff on the website? About 30% or more in some cases will say, no, thank you, right? So that means you will have an impact. There will be an impact on the amount of analytics and targeting data that you get from your website. Now, I get it. Your marketing department is not going to like that. And I understand that because they want that information because it helps them make their ads better. This is a balance you have to take that says, how much risk do I want to accept on the litigation side in order to get this information that I want that's more valuable? And at the same time, protect it from third parties that want to take it from me. So, okay. So, that means I'll just tell you this slide. I hesitate this. I don't want to paint people with a broad brush, but we have seen, because of where we are and how many dealers we serve, that there are unfortunately, some folks that don't always have the dealer's best interest in mind, right? A marketing company that's like, look, from their perspective, they need this information for a whole bunch of reasons. They want to use it. They want to show value to you as their customer. And they're going to say, hey, you can't have this banner on there working this way because we're not getting this data, right? Now, they, of course, are not the ones at risk for the litigation side of things, right? So that's why there's this balance. You have to understand, but just be cautious. If you have third parties telling you this stuff, just question it. You're sensible folks. You can figure this out. Now that you kind of know how this all works, there's going to be a trade-off. It's for sure. You just have to be sensible in the amount of risk you're willing to take in terms of how you want to do that trade-off. So again, why does this matter? Ask yourself, why does this matter to this third party? Why do they care, right? Does it really matter to you that you have this? I mean, if someone's telling you they don't want you to collect this information about them, do you want to be gathering it anyway as a business matter, right? I mean, there's a question about that, regardless of litigation risk. Okay, so I won't belabor that, but that just is the reality we're seeing. Okay, so we got some time left. I want to get to questions. I've alluded to this a couple times, but just to make the picture clear. Okay, so we said, what's the issue? What's the background we're talking about? What's the legal theories that they're using? What are the practical issues you have to think about? Now, what is the regulatory side? Just to because this is another piece, and I talked about this a little bit. There are 19 states that have so this is not a privacy webinar, but just so you understand how it works in the United States. In the United States, there's no federal privacy law that applies to everybody in the country, right? In the United States, we've attacked it by sector, right? So there's HIPAA. You might have heard of HIPAA. That's health data. So if you're a healthcare provider, you have to protect that data. Or COPPA is children's data. Or Gramm-Leach-Bliley, which you are subject to as a financial institution. Therefore, you have privacy. That's why you have to worry about the privacy rule and the safeguards rule and all the things you have to worry about as a dealer, because you're a financial institution. But what's happened is the states are stepping in and saying, if there's not going to be a federal privacy law, we're going to pass a state privacy law, right? So again, this started in California, but now that we're at 19 states, I think, frankly, we'll probably be at 30 states by the end of next year. There are a whole bunch of, this is happening right now in every state house in the country. Colorado has one. Colorado Privacy Act's been in effect for a number of years. Almost all of them address retargeting cookies. So all the things I said to you before, on top of all that, your state privacy law has requirements about cookies, retargeting cookies that you use. That they generally don't deal with analytics; they just deal with retargeting cookies. Okay, They generally require you to provide an opt-out. So in other words, I have to be able to say, I don't want you to collect retargeting cookies separate from your banner. Like it actually has to be a separate functionality under the state privacy law. You also have to do consumer data requests, third-party providers. I won't go into state privacy law. Hopefully you're using Colorado to comply with the Colorado Privacy Act. If you're not, give us a call because it's something that's complicated to do on your own. But the bottom line is the implications of cookies under the state privacy laws can be very complicated. And now the states are now starting to enforce these things. So I will note that Colorado, so again, I keep mentioning California. It's all these good ideas come out of California. California had the CCPA, which was the first state privacy law. They also actually have an entire enforcement agency called the California Privacy Protection Agency, the CPPA, that is the enforcement agents for the California privacy law. Well, some other states that are interested in this, including Colorado, have formed a coalition. You can see California, Colorado, and Connecticut have formed a coalition to utilize these California privacy resources to bring enforcement actions against people in their own states. So I'll just tell you, this has been an interesting development. You're in the crosshairs in Colorado because your state agencies have decided to work with California on this. So the first thing they did just a couple months ago was this compliance sweep on what's called a global opt-out or universal opt-out, global privacy controls, that GPC that's there. Basically, the long story short is you have to have a way. There's these signals you can send. I can go on my computer and put this signal on that tells every website I go to that I want to opt out of all this stuff. Well, that doesn't do any good if you don't recognize the signal I'm sending. So you have to recognize a signal in Colorado. We do that for you through our system, but there are a lot of folks that don't. So they had a compliance sweep on that. And I think that's just the start of more to come under the Colorado Privacy Act. Okay. So I know this gets confusing, but that's separate from this litigation risk, separate from all the other things I'm talking about. They're actually bringing enforcement actions about this. So here's another example. This is California. You can see this is Honda Motor Company. This is not Honda dealer. This is Honda Motor Company itself that the California agency brought an enforcement action against Honda Motor Company, fined them $632,000, partly because their cookie banner wasn't compliant. Right? That was essentially, they had a cookie banner. It just didn't work the way it was supposed to. It had things called dark patterns and other things that were complicated things that it was doing wrong. But they had a fine against Honda Motor Company related. It was some other things they did. They didn't handle some requests right, but largely it was about their cookie banner. They had one. It just wasn't set up the way it was supposed to. It wasn't designed the way it was supposed to, and it didn't work the way it was supposed to. So even again, my message is you got to have one of these, but you got to have one of these that works and works right. I mentioned this too. The FTC has brought some enforcement actions in this area. I won't spend a lot of time on this. It's been a couple of years, but I will tell you, it's clearly something that's in their crosshairs. I think it's probably a little less likely the Trump administration will bring more enforcement actions in this area today, but they won't be, they're not going to be there forever. And these things go back and forth. I've been in enough FTCs. They come back with a vengeance the other way. And so they've already brought some enforcement actions. They actually sent this big notice out to GLB entities saying, in particular, we're worried about you doing this without, again, it's collecting this information without proper consent. I talked about this Briskin case earlier. I won't spend a lot of time on this. For the lawyers in the audience, you might find this interesting, or some of you other. We'll see if it stands. But it was an interesting recent case because they, the Ninth Circuit basically said, look, if you're just having a website that sells things to people in California means you're subject to these California state laws, which is sort of unusual. I mean, that's the personal jurisdiction issues, extraterritorial application of the California laws. It's a complicated area of the law, and they really broadened it in this case. And we'll see. I think it's going to lead to, I think it's part of what's emboldened these plaintiffs' lawyers to bring all these claims against out-of-state defendants outside of California. So I mentioned the New York AG guidance earlier. You can take a look at that when you want to. The bottom line is, I will tell you, we felt good because everything that we do is kind of what they said you should do, including the fact that it has to be certain colors and the way you word things and the way it's done. So again, just note that it's out there. And again, New York has no privacy law, no state privacy law. It's not under the state wiretapping law at all. It's just, broadly speaking, these regulators don't like this targeting without consent. They don't. There's nothing wrong with it inherently, but what they don't like, they find it to be a very crucial privacy violation to be doing this without the the person's knowledge and without their consent. So that's the bottom line. I mentioned this a few times. Again, on top of everything else, one of the things Honda got dinged for, by the way, and some other enforcement actions are what they call dark patterns. So even if you have a cookie banner and even if it works right, you have to make sure that the choices you're giving people don't gently nudge them to accept the cookies rather than reject. So you get an example here, like literally the fact that accept all has the black box around it, and then it says manage cookies rather than, it's got to be the same color, the same box. It's got to be accept all, reject. They have to be equal choices in all sorts of ways, right? Otherwise, they think you're trying to trick them into accepting, trying to up your numbers from that 30, that's 65, 60, 70% that say yes. So again, that's a little bit squishy. Don't overlook it though. This has been the source of a lot of, and frankly, if they bring an action against you or they bring a lawsuit, they just throw this in after the fact if you're violating this. So just be aware that that's an issue. Lastly, again, I touched on this earlier. We don't help with this. I want to be clear, but this has been a little bit of a trend that we've seen lately. It's kind of weird. I think it's going to die out soon. We'll see. But I've seen a rash of these plaintiffs' lawyers that are claiming tracking in emails, which I think I mean, I'm not even sure what you would do about this because I don't know where the technology is to make sure that this is tracked. And of course, there's no banner or anything you can put it on because it's not a website cookie. It's literally you send an email and the email has embedded pixels in it. And there are claims saying that violates some of these laws. Seems to be coming out of Florida. So again, if you see this, just be aware. Unfortunately, dealers have seen these letters, and it's just something to be aware of. You got to talk to your lawyer about it, but it's my personal opinion. I think this is a little bit of a flash in the pan. Some plaintiffs' lawyers sort of testing this area, trying to get some traction. Okay, so now I've given you the panoply of horrible things. Look, the takeaway from Brad, you say Brad gave me all this complicated stuff about cookies. The bottom line is have a banner, make sure it works right, make sure it's designed properly, make sure that it's doing what it says it needs to do, and that it functions the right way. And of course, that nothing loads until the person gives consent, right? That's something I didn't stress, but that's incredibly important. And that happened in the Honda case too. If the stuff all loads before I have a chance to say yes or no, then what the heck? That's not consent, right? You can't unring the bell, right? So you got to make sure it works in a way so that it doesn't load prior to consent. But the details about the claims are less important, I think, other than to say that this is not just a privacy issue. It's not just a California issue. It's every dealer, and you really kind of have to get this right. So how do you get it right? Cookie banners. I mean, right? Look, nobody loves the cookie banner on there. It takes up space on your website. I get it. It's kind of irritating. It's in the way. People are now opting out of, you can't collect information about it. I get it. It's not ideal, but it's really the only and by far, I think you'd be crazy not to have one at this point in time. I mean, when I was giving this presentation 2 years ago, I would say half the dealers didn't have anything, right? And I'd say you're putting yourself at risk. Well, guess what? Everybody's got something now. Now the question is the one you have work, and is it working the right way? But that's not enough. You have to have a cookie banner that works in all the ways I talked about, and you also have to have a privacy policy that says the right things about what you do in terms of collecting this kind of information. So again, this is important in Colorado because that's required in the Colorado Privacy Act. You have to have a compliant privacy notice, and that's very complicated. For those of you who are our customers, you can look at the privacy policy we give you in Colorado. It's very detailed and very complicated, but you have to have that as part of your compliance. So it's not, the banner is important, but that's not the only piece. Again, I will mention chat modules. The chat litigation was really big probably 18 months ago. It's died down a little. It's less prevalent now, but it's not nothing, right? That's a whole separate issue where the problem is this chat box pops up. It's actually, you don't realize it, but it's a separate embedded iframe website that has its own cookies that load on it, right? And all of a sudden, you've just blown a hole in your issue, right? The person said no before, and all of a sudden you're loading cookies on the chat line, right? Or vice versa, right? So, and you can't really have two, and they can't be different. So it raised a lot of issues. Just be careful about chat modules and other iframes. Here's an example. This is the California example, but this is an example of the Colorado cookie banner. Again, each of these things are important in the way and relevant in the way that it works. Again, it has to block everything at least all marketing that has analytics and targeting cookies until the user accepts. Once the person says allow all cookies, load whatever you want, right? And use it however you want, right? There's no restrictions on it. It's consent from the consumer that you have to be able to prove. So the basic choice you have to make is, are you going to block all analytics and targeting cookies, or are you just going to block targeting cookies? I would suggest you at the very least, you block targeting cookies. That's where the real threat is. That's where the requirements exist under Colorado Privacy Act. I would say that's sort of the standard. Certainly what we recommend at the least is block all targeting cookies until the consumer says yes, right? In that circumstance, the analytics are all loading prior to consent. That's a risk because there have been cases brought, even though it's not targeting, there are claims made that these analytics cookies alone are enough to violate some of these restrictions that I talked about. So it's not risk-free, right? So to really manage your risk, a lot of dealers will block both analytics and targeting cookies until the person says yes. That's really the biggest choice you have to make. I mean, I would never suggest blocking everything. I don't think that makes sense because, of course, you need certain things for the website to function. I also wouldn't let everything through, right? Then you have no protections. But that's essentially the choice, the fork in the road you have to come at. Am I just blocking targeting until consent, or am I blocking both? And again, you can geofence it. So if somebody's coming from California, you block both. Right? Because a lot of SIPA claims come on analytics cookies. That's something people don't really realize. It's not just limited to targeting cookies, but the targeting is higher risk because you have privacy law implications, and frankly, courts have just they've looked on targeting cookies differently than analytics, right? If you're loading something that you're just using to analyze your own website, the implications of that, just the policy implications, are different than if you're using it to share it with a third party to serve up ads across the internet, right? So I won't belabor it other than to say that we have settings, set them how you want, work with your marketing department to figure out what the impact of that choice is going to be. And then you can set it up based on what state you're in, how you want to set up the geofencing and the rest of it. Okay, so again, I mentioned this, but look at this when you can. Get affirmative express consent before it's loaded. It can't be confused. It can't be dark patterns, all those kinds of things. The language has to actually do what it says it does. You have to have policies, including a privacy policy that works. Look, understand what's happening on your website. There are some steps you can take. You can route the data through you, which is sort of more of a first-party cookie concept. Then you get control over who gets access to it later for all those important business reasons I talked about. Again, you can read this, limit the content recorded. I mean, think about what you really need. Why would you be recording everything that happens on your website? If there's only certain things you care about, then only target that, right? That's going to limit your exposure should it come. And of course, the lawyer and me, look at all your contracts. I mean, you saw those hundreds of cookies firing on that website. Do you know what cookies are on your website and who's doing it? And do they have permission? And what are the restrictions that are used to that information that you have with them in your contracts with them? So that's a little bit of work on your end, but it's like giving access to people in your DMS, right? You wouldn't do that without some controls on it, right? So it's just one of those things that I think dealers need to be more aware of. Again, ask your vendors what's happening on your websites. Tell me what cookies are loading. What are these cookies, right? Just asking can illuminate a number of things. I won't go into all this. Again, I've been enough of these calls. You need your marketing team, you need your legal team or your policy team to sit down and say, where do we want to set our cookie banner settings? Set it, maybe even test it for a while. If you think it's too much, too far, too little, you can adjust it always, but just make an informed decision as you go forward. And it's your choice. It's entirely your choice. Again, I'm not going to go through this. It's not just in California. Everybody needs a banner. I've reiterated this a number of times till I'm blue in the face. I'm just telling you, I hear the same things over and over again. Oh, we don't collect NPI, so it's not an issue for me. That's not the deal. That's not what we're talking about here, right? I'm not in California, and I don't have to worry about it. You do have to worry about it, okay? So I won't reiterate it here. Just be aware. There's a reason these things have become ubiquitous. There's a reason they're on there, and there's a reason you have to get it right. Again, you got to have a banner that works. I've seen this more in the last 6 months than I think over the last couple of years. Increasingly, the lawsuits have switched from you don't have any banner at all to the banner you have doesn't do what it says it does. And I'm going to bring a class action based on everybody that's visited because you just deceived. You were deceptive in what you did, right? It was unfair, deceptive to have a banner that doesn't do what it's supposed to say. So again, I'm repeating myself on all these cases, but just, know what's happening on your website, understand it, get control of it, make an informed decision, and get a banner that works. Last thing I'll tell you, and I'll get to a couple questions here, hopefully, but last thing I'll tell you is that we just rolled this out. So even if you're one of our customers that uses Comply Auto, if you're not a Comply Auto customer, call us. We'll help you out. Use somebody. I mean, we just have a better tool than what else is out there. But whatever you do, protect yourself somehow. But use us. If you're a Comply Auto customer, you may not know this. We just rolled this out in the last sort of few weeks. We actually roll out what we call we use AI to go out there and look at all the cookies that are loading. Remember, we got whatever 10,000 dealers, more than that in websites. So we're getting these massive amounts of data, figuring out which of those are analytics and which are targeting, and which can be tough sometimes, right? So we have a whole team of people that does this, but we're now employing AI to categorize all these cookies, right? So that you'll know when a new cookie comes onto your website, and we're going to say, this is what we think it is, here, and give you some choices and some power and some insight into what's happening. Because a lot of times, people will load things on your website and you don't even know it, right? So I think this is one of the most powerful tools that exists out there. It'll give you some details about what the cookie is, where it's coming from, so you can make a decision about whether you want to allow it or not allow it, agree with the way that it's been categorized, et cetera. So again, this is a huge new. It does kind of, I think, as of now, it has to be set up individually in your account. So if you're one of our customers, call your CSM and they can get you set up on this. It's a really cool tool. For those of you who don't know, obviously this is part of our privacy software. It's just one piece of our privacy software. The privacy software helps you comply with the federal safeguards rule, the federal privacy rule, the state privacy laws, and then obviously we have the cookie banner that's tied into the DSAR portal and the rest of the privacy policy and the rest that we do. So there's a whole piece of this vendor management safeguards. I'm not going to talk about all that stuff. We have technical tools that we sell, like cybersecurity tools that are part of this as well, that are optional, but just so you know, they're out there. Look, we're in 10,000 dealers. There's a reason we're so popular. It is incredible software. Will make your life a lot easier. And frankly, both at a federal and state level, we talked about the cookie banner, but remember, this is state privacy law compliance, federal privacy law compliance, all the things you have to do. I mean, it's critical and frankly, it's basic cybersecurity, right? That's the other thing is our cybersecurity tools are so powerful that really it's sort of a business imperative to be doing these kinds of things anyway. Again, if you get some of our tools, we actually have $1 million breach warranty that comes with if you get our MDR protection. I won't get into that today, but just be aware of it. And we didn't talk about this, but we also offer EHS and safety. If you don't know, that's relatively new. And our Guardian and Deal Check products are brand new. So Guardian is an advertising compliance tool. Look, by the way, on Thursday, we're doing a webinar for everybody in the country on that FTC notice that went out to 97 dealership groups about advertising. Guardian is something you should be top of mind today. It is an AI-driven tool that will look at all your ads under both all federal and all 50 state advertising laws and analyze them and spit you out a report every night to tell you what's going on. It's a very, very powerful tool. I'd encourage you to listen to our webinar on Thursday if you want to hear more from me about the about the advertising stuff. I know it can be complicated, but the FTC is sending a big red light that they're very focused on this. So again, I won't go into that too much. All right, so we have a couple minutes left. I'm so sorry I've talked a lot. I got some good questions in here that I want to get to. So let's see, a couple questions. I have to read this one. My understanding of Colorado law requires disclosure, does not require. So, all right. So hopefully this was a question that was asked earlier in the program, but it's a great question, and I get this question all the time. Colorado law, privacy law, I think they're referring to, requires disclosure and maybe even the opt-out for targeting cookies, but doesn't require a banner, right? Necessarily. And that's mostly true, although I would quibble a little bit because of the privacy policy piece of this. But let's just assume that's true. And the bottom line of this is, look, this has such a drastic impact on my analytics data. Do I really need to do this? Am I really required? Hopefully that was an early question in the summer. I get the question all the time. It's a great question. And I be honest with you, most lawyers don't understand the answer to that question. The answer is, for all the reasons I said, everybody needs a cookie banner. I mean, they just do. Again, you could look. Would you go out of business if you didn't have one? Are you assured that you'll be sued? No. But will you be exposing yourself to potential liability under state and federal law? Absolutely. Under all those theories I spent the first sort of 15 minutes talking about. So it's a very, very good question. I get it, because I look, there's nothing wrong with analytics and there's nothing wrong with targeting in my mind. There's not, again, the key here is consent. And again, you're right. You give consent, some people are going to say no, so there's going to be impact on your analytics data. So it's kind of a hard pill to swallow. It's a bitter pill, but it's just the reality. So again, there are settings you can have to make the impact less or greater, and the protections less or greater. You'll have to make those choices for each of your own dealerships. So next question. Web browsers have a setting for denying the setting of cookies. And if that's turned on, would that cover the requirements? It's a complicated question. There are actually some settings you can do in places like Google Consent Mode and things like that I think would have impact. And you could talk with our technical team about ways to employ those kinds of tools to help you. They really give you a defense after the fact more than anything else. I will say, I mentioned this earlier. Remember, Colorado teamed with California and Connecticut to talk about those global privacy controls under your state privacy law. So the Colorado Privacy Act requires you to honor these global privacy controls, and those are driven by the browser, and you do have to have a way to honor those. So like I said, I can have a setting on my browser when I'm on the internet that sends out a ping to everybody. It's a universal opt-out. Everybody, I'm opting out of everything, and you have to make sure that you have technical means to honor that. So if that's being pinged out there, you've just opted them out of everything preemptively, right? So I think targeting actually is limited. I have to go back and look at Colorado exactly what it says, but I think it's just opts them automatically out of targeting. Then the question is, what do you do with analytics? But very good questions, and again, technical issues you can work through. If you're one of our customers, you can work through with your customer service rep because they're important. At the end of the day, there's lots of leverage you can pull. We're sort of just giving you the tool, right? I mean, we're doing our best to give everybody what they need. And allow you, just like I said, set it from 1 to 10. But I would get something on there. I mean, I'm a little probably more conservative on this stuff. I'm not a marketer, I'm a lawyer. So I'm more toward the compliance side than the marketing side, but I get it. And I can see either way, right? So great questions. How are customer requests for data deletion handled? So good question. Slightly separate topic. That is just so everyone knows, well, I didn't spend a lot of time on this, but the Colorado Privacy Act, remember those 19 states that have state privacy laws. What those privacy laws broadly do is they say every business in the entire state of Colorado, and not just dealers, you have to meet certain size requirements and other things. But basically, every business in Colorado has to take steps to honor. Every consumer in Colorado gets rights. I get the right to tell you, hey, I gave you my data. I want you to delete it, or I want a copy of it, or I want to correct it, or I want to know what you have about me. And you have to honor my requests in a certain period of time, in a certain manner, and not do certain things, right? So the question here is, how do you handle Brad Miller comes to you and says, I want you to delete all the information you have about me? The answer is, that's a complicated other hour webinar we could do. And we've got them online if you want to look at it on our website. That's compliance with the Colorado Privacy Act. Excuse me. And it's a great question. And the answer is, you have what's called a DSAR portal, Data Subject Access Request portal, where the person could go and make the request. And at least in our system, we then handle the request for you. We determine what data the person has. We make sure that we did the identity check, and then we send the letter and we delete the data, and we have the third party delete the data. So it's a complicated, excuse me. It's a short answer to a complicated question. That's a little outside the scope of this. That's Colorado privacy law. Very good question. We could always give you more details on that if you want to reach out to us directly. Have any dealers been fined under the 19 state privacy laws since those laws were enacted? So, good question. The oldest is the CCPA, and they've been the most active in bringing fines directly into the state privacy law. So remember, there's sort of two different things. There actually are private rights of action that you can bring tied to these state privacy laws, even though there's no private right of action in the law. So I'm getting in the weeds here very quickly, but There have been a lot of cases I've seen where claims are raised under the state privacy law against companies because of a violation of law, right? So let's put that aside. Those are lawsuits. If you're asking specifically, have the state enforcement agencies brought fines against dealers for this? No dealers yet that I'm aware of, but there has been the one against Honda. In fact, Ford Motor Company was also recently just fined under the CCPA. So they've started at the OEM level. I've heard anecdotally in California, the next level they're going to is the retail level. And I've heard anecdotally they're talking to them. None reported yet, to be clear. And remember, in the other states, these privacy laws are all pretty new. Like Colorado is one of the oldest ones, and it's only been around a couple of years. And Colorado doesn't have an enforcement agency like California does, which is why I think it's noteworthy they're working with California. So they first went after that global privacy control thing and did a whole compliance sweep. I think the next thing that's coming is enforcement actions with California against multi-state companies of any. Remember, these state privacy laws apply to every business in the state. They're not just dealer specific. So they've gone after, like in California, they went after Sephora, the perfume company, you see in the mall. They had a huge multi-million-dollar fine because of the CCPA violations. Ford Motor Company, Honda Motor Company has been fined. There have been some other companies fined in California that have been by far the most active, but I think it's coming to the other states. So all those, that's a very good question. So, there's a question here. I think it was got some. I'm more than happy to chat with you if you want to reach out offline. Look, I sense the skepticism. The question really is: so if I confirm that my website provider honors the global privacy control signals, which again, that's great. If that's true, I would query a little bit because I know we do that through our banner and we work with a lot of the website providers. So again, just be sure about that. But if they can be sure that they honor that global privacy control, are they going to be in compliance? Again, it's just not that simple. That's why I spent all that sort of first 15, 20 minutes laying the background for you. It's complicated. And I understand that it feels like it's not something you want to do or have to do. But I would be, I can see no circumstance why any company that has a website that collects anything from any person or loads any kind of tracking or analytics cookies on it or retargeting cookies would not want a banner on their site. It's just the reality. So again, you can set the settings of the banner how you want, but I would have one. I would not be flying, naked without one. I mean, look, if nothing else, without a banner, you're just a huge. People don't even have to do that whole process where they inspect your website, look at the cookies, make allegations about what you're doing. They just say, you don't have a banner at all. You didn't get my consent, right? And so I'm suing you. So can you run with the herd and avoid lawsuits? Maybe, but these are starting to become much more prevalent. I mean, again, it's a risk reward question you have to answer for yourself. I would never suggest a dealer not have one. So great questions. I don't want to downplay it because I get it. Look, it's going to have an impact on your analytics data. It could even have an impact on your targeting data. You can adjust those settings. I get it, and I wish the answer was different, but it's not something I would suggest. So, okay, I've gone a couple minutes over. I think I've hit most of the questions. My contact information's here. If you feel free to reach out, or I can get someone from our team. We got a number of lawyers on staff that are more than happy to help anytime. Look, I get it. It's like one of. I mean, some of you may remember 5-6 years ago there were a whole flurry of lawsuits on ADA compliance on websites. Right? It was kind of like, really, you're suing me for this? Well, people got the ADA tools on the website, and I'm assuming we still see lawsuits on that sometimes. So don't fall asleep on it. But it's a lot of these are the same firms doing this, right? And in addition to the litigation side, I'm just telling you that this is becoming more and more a focus at the regulator level. They just don't. They have a notion that this retargeting in particular is highly problematic from their perspective. Again, you can avoid all this with consent. Get consent the right way. Get a banner that works. Get one that makes sure that's not using dark patterns and using the right language. As best you can do. So again, I hope that helps. Great questions from everybody. Thank you everybody for joining. I know I've gone over a little bit. Hopefully this has been helpful. Call us if you have any questions about this or any of the other products we work with. We work with dealers every day on this stuff. We live and breathe dealer compliance. That's what we do. We're very interested in making sure dealers are protected. And so, we want to help you if we can. So thanks again to Colorado folks. Thanks, Christy, for having us, and hope that was helpful, everybody.
Thank you so much, Brad. I really appreciate your time and expertise.
Thanks for having us. All right. Thanks, everybody. Have a great afternoon.